Hello, my name is Agnieszka Piasecka and I am an estate planning attorney in Clearwater, Florida. Today I would like to discuss with you advantages and disadvantages of estate planning, possibly creating a trust or other documents for you and your beneficiaries. Let's start with talking about a trust in Florida. A lot of people ask me what is better, trust or will? What is the difference between those two documents? So the principal difference between will and a trust is that one avoids probate and another one doesn't. A will, basically, essentially, last will and testament and a trust, they essentially achieve the same goal, which is disposing your property in the event of death. However, there is a huge difference. A will goes through probate, which means it requires to be filed with the court and supervised by court before your beneficiaries can get access to your assets, and a trust avoids that. So by creating a trust, you can save your beneficiaries a lot of money and a lot of trouble. For you, it's probably easier and cheaper to create a will. However, for your beneficiaries, it's going to be expensive and it's going to take time for them to be able to access your assets. So they would definitely benefit from you planning accordingly to help them avoid probate and avoid potential obstacles in getting access to your assets. In both documents, a trust and a will, in both documents you can include provisions regarding your last will. What would you last wishes? What would you like it to happen with your assets in the event of your death? You can also put backup beneficiaries. So, for example, if one beneficiary doesn't survive me, then who gets my assets? In a trust, you can also include some more sophisticated planning. You can, for example, hold the money in a trust for a certain time if the beneficiaries, until the beneficiaries reach a required age, or until some conditions happen. For example, they obtain a college degree. So trust gives you a lot of possibilities. When you are thinking about which document to choose, also think about other advantages that a trust may have over a last will. A trust is a confidential document, while a will gets filed with the court and becomes public record. So if you want to keep your estate matters private, it's better to have a trust. Also, with trusts, you can choose specialized types of trusts. There are trusts that, for example, can provide for your pets, or you can include provisions in your trust for your pets. It doesn't have to be just for your pet. You can provide for your family, for your beneficiaries, and by the way, you can also provide for a pet. You can also provide for charities and for disabled beneficiaries. There are specialized types of trusts that can help you with that, and certain trusts can be also created to protect you from creditors or protect your assets from creditors. And even there are some trusts that serve to hide the investor's identity if you're buying real estate and you don't want it to be public record. So you can choose from a variety of specialized trusts. However, the trust of interest for today's video is the probate avoidance trust. So that trust essentially makes sure that your beneficiaries don't have to deal with court proceedings, with probate, which in Florida can be very expensive. because the cost of probate in Florida is calculated based on it's a percentage of the value of the estate, so it may be very costly to have to do probate in Florida. While you're thinking about creating those documents, you also have the option to create other documents at the same time, so that way you can have your entire estate planning package created, and it's usually much cheaper that way if you order all those documents at once at the time of your trust or will creation than if you were to create those documents separately at a later time. My office offers flat fee packages for more than one document, so make sure to inquire about that if you call my office. What does a typical standard estate planning package consist of? So in a situation, if you choose a trust, the estate planning package will start with your trust. That will be your principal estate planning document. And like I said before, in this document, you would want to list your beneficiaries and provide what's gonna happen in the event of your death, what's gonna happen with your assets, how do you want your assets to be distributed. You can list backup beneficiaries, you can list a charity organization, you can include your pet, and in a trust also you need to appoint a person who's going to administer that trust after your death. So during your lifetime you appoint yourself, and that's called, you're going to be a trustee. That person who administers the assets, the trust, that's a trustee. However, upon your death, you need to have a person who's going to take over. So you typically appoint a person as a successor trustee. This person should be a person of trust. It can be one of the beneficiaries. So for example, if you're leaving your assets to your children, you can appoint one of your children or even all your children as successor trustees. They can act jointly or one of them can act separately. And you can also appoint backup successor trustees. So if one of them does not survive you or cannot serve, then who serves in their place? The same you would do for a will. So if you're creating a will, then the same, you will have to state what's going to happen with your assets, with your estate upon your death, and who do you want to be an administrator of your estate, which in a will is called personal representative. In addition to a trust, usually we also create a will. So a will serve as a backup for your trust. It's called a pour-over will because it catches what was left outside of the trust and pours it over to your trust at the time of your death. So the will serves as a backup to your trust, and it serves the purpose to minimize the probate proceedings. However, in order to completely eliminate the probate proceedings, the goal is to fund your trust during your lifetime with all your probate assets. So anything which normally should go through probate should be put in your trust. Before putting certain assets in your trust, you may need to contact a tax advisor or your attorney. So make sure when you are creating a trust to talk to your attorney about it, to ask which assets should I be careful about, which ones can I just put in the trust without any considerations. There are certain types of assets that you may need to contact your tax advisor before you attempt to put them in a trust, because that could create you some tax consequences. However, generally during your lifetime, you shouldn't, nothing should change for you. If you create a probate avoidance trust, it works like as a will, you know. During your lifetime, everything should remain the same. You still own your assets 100% and you manage your assets, and the situation changes after your death. Your assets will pass by operation of law, by operation of trust, to your beneficiaries without the need of court proceedings. Together with your trust, we would also suggest that you think about creating a power of attorney. There are two types of powers of attorney. Generally, two main types. One would be called durable power of attorney, and another would be a medical power of attorney, which is in Florida is also called appointment of healthcare surrogate. And those two documents serve in case of serious disease, serious illness, or loss of mental capacity. In a situation when you can not communicate with institutions, doctors, or you cannot sign documents, or you do not have mental capacity to perform certain actions, sign certain documents, take care of certain matters. In that case, the person that you appoint in those documents can help you and can do it for you and they don't need your signature, they don't need your presence. So durable power of attorney survives mental incompetence and helps avoid guardianship proceedings. So that's a very helpful document if you need someone to be able to take care of you and to help you in case of illness or loss of mental capacity without having to go through court proceedings. Another document would be a medical power of attorney, and that document has a special language for hospitals, for medical providers, to be able to release your medical information and to be able to allow other people to make decisions for you, medical decisions for you. And that's a very important document because of HIPAA regulations. If you do not have such a document in place, most people will not be able to get information, medical information about you, or make any decisions because they don't have power of attorney to do that. Typically, a spouse doesn't need a document. A spouse can talk to your medical providers about your health and also make decisions for you in case you cannot, but other relatives or friends cannot. Another document which we typically prepare together with your trust, will, and powers of attorney would be a living will. People very often confuse living will with a will. Those are two different documents. So a will is basically a last will and testament that comes into place after your death, and it basically states how you would like your assets to be divided, distributed after your death. A living will is a document in which you can decide if you want to be artificially held alive by machinery in case of a very serious illness, for example, vegetative state or end stage terminal condition. So that document is also called an advanced medical directive, and in other words, living will. And that document also typically is prepared together with the other documents that I mentioned. The last document that we also typically prepare is a declaration of pre-need guardian. That declaration of pre-need guardian serves for the court to see who you wanted to be your guardian in case guardianship proceedings will have to be administered. So in case of loss of mental capacity, a guardian needs to be appointed unless you left someone a durable power of attorney. That way you may not need a guardian. However, if there was no durable power of attorney, or if there was a durable power of attorney but it later was revoked, then that declaration of pre-need guardian may be very useful, because in that document you get to appoint the person who you would like to serve as your guardian. And that should help you avoid a stranger being appointed to be your guardian, which in Florida is a big problem. There are a lot of professional predatory guardians in Florida who prey on people with assets, and they sometimes petition for guardianship when they see there is a person who has a lot of money, a lot of assets, and needs to be helped, you know, and they are professional guardians. They not always have your best interest in mind, unfortunately. They're called predatory guardians, and it's really good to have a declaration of pre-need guardian in place in order to avoid those type of situations. How does a estate planning package look? So usually it's created in the form of a portfolio. I can show you as an example a binder that I usually give to my clients. So a typical estate planning portfolio would look something like this. This is a binder that I may give to my clients if they order the estate planning package with a trust. So here are the tabs, and each tab corresponds with the document which I would prepare for a client. Here is how a typical estate planning portfolio would look like, for example. So I would strongly encourage you to actually consider creating an estate planning package, because it's cheaper. It has a huge advantage that you get everything taken care of at once, and you also get yourself covered on all fronts, not only in case of death, but also in case of serious illness or loss of mental capacity. And also it's good to remember that all those documents that I just discussed, they need to be prepared when you still have mental capacity. You need to have mental capacity to understand the nature of the documents that you are signing, and be able to voluntarily sign and fully understand the consequences and the nature of those documents. So sometimes when people start having dementia or other cognitive problems, it's too late to create those documents for them. So that's another thing that you should consider when you're thinking about taking care of your estate planning. My law office offers a free telephonic consultation, the first free telephonic consultation about estate planning. So you can always call my office and ask if you have any additional questions, or if you would like me to explain particular documents. I'll be happy to talk to you about it. My number to reach me directly is 813-786-3911 or 727-538-4171. Thank you very much for listening to this video, and I hope you enjoyed it. If you would like to check some additional information about my services and myself, you can also visit my website www.piaseccalaw.com. Thank you.